At times, it seems the Supreme Court runs the country. These are the opening words of a new book that takes us through 15 key landmark verdicts from the Supreme Court. I'm Barkha Dutt, you're with the Mojo Story. Our focus today is on the author of a new book, Saurabh Kirpal, senior advocate and author, who takes us inside 15 landmark verdicts that he argues have changed India's financial landscape. In this book, we look at several important moments in legal history from the time that banks were nationalized to the Aadhaar case to, well, yes, even how women like me get protection at the workplace against sexual harassment through a case that we now know as the Vishakha guidelines. These are critical cases and we barely even notice them. One of the things that Kirpal underlines in his book is the absence of legal awareness and the absence of space in the media when it comes to actually talking about these cases. Saurabh Kirpal himself, of course, has been recommended to be a judge not once but 4 times. Why that hasn't happened is also something we'll ask him as we talk about his new book. Bringing up a newsmaker on the program today, Saurabh Kirpal, and I have to say at the beginning, an old friend, someone I went to school with. So full disclosure there, but it's good to see you after many years, Saurabh. A fascinating book, and I was particularly fascinated by the opening line of the book. At times, I'm paraphrasing, at times it seems the Supreme Court runs the country. So let me start by asking you, do you think the Supreme Court runs India today?
Thanks for having me, Barkha. And I'm sure even though I'm an old friend of yours, you won't be easy on me. Uh, and good for you. Uh, yes, the Supreme Court does appear to be run in the country. At the very least, it seems to try to run the country. When you read the papers in the morning, especially on low news day when there's not much else making the headlines, I think the entire page 1 to page 3 seems to be a reportage of what the Supreme Court decided or what a particular judge said on a particular day. So matters relating from BCCI and cricket to the environment, all these issues and appointments and politics, all of this seems to be within the domain of the Supreme Court and the high courts. Whenever there's an issue that should be dealt with politically, parties often take it to the court rather than fighting it on the political arena. So yes, it's true that I think the Supreme Court runs the country, tries to run the country, but is not always equipped to run the country.
How do we understand this sort of epicenter role for the court at a time when actually, arguably, we have one of the most powerful in sort of electoral victories in fueling the government? You would imagine that there would be a kind of jousting for influence between the court and the government, and in some ways it's happening. We've seen the law minister in fact questioning whether the collegium system is the best way to proceed. So why do you think the Supreme Court ends up with this inordinate influence in India's politics when you have a powerful, legitimate government with massive electoral endorsement?
There are a couple of reasons why. One is, of course, the historicity of it. The court became immensely powerful in the mid 80s to the late 80s. It started the concept of PILs to atone for its perceived sins of not standing up in the emergency. And through the modem of PILs, it got moral authority and became a very powerful institution. And some part of the court's role today is a reflection of that power that it had gained through its moral uh, superiority, I would say, over the politics of the day. So that's one aspect of it. Second, but this is a diminishing resource, let me tell you. The moral authority of the Supreme Court has taken a bit of a battering. And just because you are powerful in the 80s, 90s, and you continue to have wield that power is going to diminish if you don't do enough to sustain it. The
Why?
corollary of that is
Yeah, okay, go ahead. Yeah,
the
go
corollary
ahead.
of that is the legislature, the executive wants sometimes to have their decisions stamped, get a stamp of approval of their decisions because the moral authority of the Supreme Court will come to their benefit as well. So it is sometimes the executive wants the court to intervene and decide matters. So when they dismiss a PIL, for instance, which raises a question, you can always say, look, the court has okayed it. So it's not as though there's always a tension. Just because a court is dealing with a difficult question, we have to examine how the court deals with it. And of course, there's a constitutional role that the court does have tremendous powers under our constitution, and quite unlike a lot of others. So that's a legitimate exercise of power.
If you had to look at, by going through the legal archives as you have for your book, or just by the practice of being a senior advocate, identify that one reason why you think the moral authority of the court has over the years taken a bit of a battering. What is that reason?
I think there is a perception that the fearless independence that the court displayed in taking up and deciding an issue, good, bad, or indifferent, uh, and the perception that once they decided they would stick with that decision, that seems to have taken a bit of a battering. A large number, I think, of matters that deserved to be heard on an urgent basis, which were matters of tremendous public interest, uh, which was really the role of the central role of the court to have heard the 370 demonetization, electoral bond, a whole host of cases one can mention. The court simply sidestepped them, right?
Yeah,
They
yeah.
didn't take a decision one way or the other, and by not deciding, you effectively ruled in favor of the government without deciding it. So that was a free pass that was given. Uh, I think that is a problem, and that is one of the reasons, I think, probably the biggest reason, that the court has lost its moral authority. You can no longer rely on the court to come and decide as you once could possibly.
So you're saying that when you delay hearing critical issues, 370, electoral bonds, demonetization, even without seeming to take the government of the day's side, by opting for status quo,
Yes.
in a way, you are not coming across as independent enough.
Of course, look, see the demonetization case, right? Now, assuming the Supreme Court was today to say that demonetization was wrong, it's absolutely pointless, right? It's been there. You can't undo, you can't unscramble this egg. Same thing with Kashmir. If you ultimately decide that 370 was wrong, there is no way you can possibly undo it. So their perception is that only those cases which merit hearing as per certain powers get listed and heard, and other matters which are important don't get heard. So there is that is a significant undermining of the authority of the court, and that might be intentional, that might be completely unintentional. That could just be a chief justice saying, okay, that's just it's a difficult issue, I don't want to deal with it, and without fully thinking through. I'm giving the most positive spin I can as to why these cases have not been heard. So it could just be dereliction, uh, or worse.
Yeah, that's a reasonably grim point to make. That delays itself can actually diminish independence. Sort of on your book itself, from Aadhaar to Vishakha, Aadhaar is an interesting example of what you're arguing. Why should the court actually? Why do we trace the ownership of Aadhaar to the courts when it was very much a kind of decision started in one government and brought to fruition under the next? So it's actually across political trenches. Yet you look at it through the prism of the court in your book. Why is that?
Well, the matter did ultimately go to court because there was a twin kind of a pull. One was the argument of the government that the Jan Dhan Aadhaar mobile scheme, the JAM scheme, so to say, will revolutionize the economy of the country, and the beneficiaries would get all that they possibly could have wanted through the Aadhaar scheme. And you're right, this was a cross political view. Uh, Each side objected when they were not in power, but this was the political consensus. On the other hand, there was a very legitimate concern about the privacy of the individual. Right? I think we forget today that when the Aadhaar scheme was actually rolled out a few years ago, I think the government probably went a bit too far in asking for Aadhaar for virtually everything. Uh, so if I remember going to the post office, and before I could post a parcel, my Aadhaar card was asked for. You needed Aadhaar for KYC, for having your mobile number uh, verified. And any interaction that you had with the public or the private sector, the Aadhaar was required. But of course, this was very dangerous for privacy because the state could completely profile you and see exactly what is it that you are doing. So the courts did what they typically do, which is balance rights. Right? On the one hand, there is a right to privacy, which was fundamental to
Chandrachud, and which was Chandrachud's sort of epochal judgment, as it were, the right to privacy judgment. And how did that
absolutely.
square with Aadhaar, according to you?
Well, the when judges sit in benches of nine, they often like to wax eloquent and talk about rights and give you rights. And the problem is when you try to bring that into practice, right? So applying a beautifully worded judgment, which is speaking to history, which the privacy judgment of Justice Chandrachud Puttaswamy was, when you actually use the nitty gritties of it and apply it to the facts of the case, Justice Chandrachud, who was a author of the main judgment of privacy, became a minority judgment in the Aadhaar case. He wanted to strike down the act, saying that it had been passed wrongly as a money bill and many other reasons. He believed that there was an inadequate compensation of privacy vis-a-vis the purported benefits.
Yeah.
So that's what happened. And but that is the role of the court. That in there, I don't think the court got it. Well, the court may have got it right, may have gotten it wrong, but the court didn't exceed its jurisdiction to enter into that arena, unlike certain other areas where I think the court has exceeded its jurisdiction.
So let's talk about a little bit about, when you look at these 15 judgments that are profiled in your book, you then have to square it with what the role of the judiciary is. Has it overreached? Has it undermined itself? Probably in different cases, different things are true. What is the one thing that unites these 15 judgments? Because in your introduction, you also write about the court swinging from socialist left to center right.
One thing that I've noticed in this judgment is that the fight between the executive and the judiciary has been a constant theme. From the 50s, when the judgment on abolition of zamindaris came, which led to the First Amendment and the wholesale removal of constitutional rights, to more recently in the for instance, the Bitcoin case. That's the last judgment that I discussed. That the RBI tried to ban Bitcoin, but the court struck down that action and upheld the validity of Bitcoin. So there's always been a tension between the courts and the executive, and that I think is a very healthy thing in a democracy, right? We don't want there to be two streams working in tandem and helping each other. That is the very antithesis of a system of checks and balances. So I think the theme that unites is this antipathy between the two, the friction between the two. But what's also interesting is how the courts have been little more, um little less more reluctant to strike down legislative acts in the recent past, and also how the inevitably the executive reacts to decisions of the court. I think that is also an important factor that should be considered, because amending the laws to undo a judgment of the court is, of course, within the power of parliament. But you wonder whether that's always a wise thing to do. So, take the Vodafone case, for instance.
Yeah.
Along comes a judgment upholding the rights of Vodafone and striking down the tax department's demand for a vast amount of tax. But then you go ahead and change the law thereafter in the UPA government. The NDA government comes and they also don't repeal this. So there's unanimity again in this front, and that did such tremendous damage to India's image worldwide in the form of economics. It was so not just the action of the court, but the reaction of the executive to the action of the court, which has also determined, I think, the financial landscape of India.
So the ongoing sort of jousting is over the collegium system. And here I actually, before I ask you, your view on whether the collegium system needs reform or not, I want you to talk a little bit about yourself. You've spoken about this tussle between, the court and the judicial, sort of the executive being constant. Look at your own case. The collegium, which is under debate today, has cleared you to become a judge since 2017, 4 times. And every time, it is the center that has actually declined to move that ahead, right? How does the collegium system work if the collegium has recommended this, in your case, multiple times, and the center is able to push back?
Well, the center is doing what the courts were doing, right? By not deciding, you are deciding in a manner. So those judgments and issues that I mentioned earlier, the electoral bonds, etc., by not deciding, you are effectively permitting the government to go ahead. And the same thing here. Theoretically, it is a collegium system at play. It's working. It's just that by simply sitting on a file, you have effectively exercised a pocket veto. Right? Now, that was never the intention of the decision of the setting up of the collegium system, but that's how it's being operated. Uh, And just one minor correction. Yes, the collegium has not recommended my name 4 times. They've written to the government 4 times saying what is the
Yeah,
material
yeah,
against me,
yeah.
and that has not been forthcoming. I hope, because there is nothing. I think I'm reasonably a safe guy, uh, but this is just an instance of constitutional functionaries, which the government is feeling that you may not like a judgment, but you have to adhere to the spirit of that judgment, right? You can't start giving your own spin and saying, I will now subvert a particular decision because I do not agree with it. That is absolutely antithetical and destructive of the rule of law. Good, bad, indifferent, you've got to do it. And it's for the collegium to consider as to how to ensure that that actually happens.
Well, that's what I was going to ask you. Please correct me if I'm wrong. I'm not a lawyer, but the collegium, as I understand it, has the final word on who will be a judge, right? The center can sit on the file as they have with in your case. The center can object as they have in your case to your partner being of a foreign nationality. But ultimately, please correct me, who do you hold responsible for the fact that today, as an openly gay lawyer, you're not a judge? Is it the center or is it the collegium?
I think it's both of the above. The Supreme Court took its own sweet time to clear my name, because the system is a two-tier recommendation. The High Court recommends it, the Supreme Court clears it, then it goes to the government. If the government says no, it sends it back to the Supreme Court. And if the Supreme Court reiterates the name after the government's rejection, the government has no option but to appoint. So that is the constitutional scheme after the judgment of the collegium system. So, firstly, I'd say that the Supreme Court took its own time to clear my name, almost 3.5 years. So, to say that it is the government alone to blame would be a bit disingenuous, because if the courts can take 3.5 years to finally consider the name, then the government has merely taken one, right? But of course, this should not be a race to the bottom, right?
Yeah.
What is the point of saying that they took 3 years, so we'll also take 3 years? That is not how systems should work. And that brings me to a real problem, I think, is while in other matters there should be friction, in judicial issues, there should be friction between the government and the courts. But in matters of appointment of judges and in administrative matters, this friction is entirely unnecessary, and in fact destructive of the rule of law. So I think there is that problem, that the insufficient coordination and communication between the two organs of the state, namely the courts and the executive. So that's the problem.
As someone who actually was part of the legal team that must be credited with the decriminalization of homosexuality, with the reading down of 377, um, for you to be openly gay and have that be used, whether by the delays in the collegium system or by the center sitting on that file, as a way to actually professionally obstruct you. And the reason they've cited is that your partner is not Indian. One of the things you've said is that if you were not gay, your having a foreign partner would be viewed as through a different lens. Can you speak a little bit about that?
Well, that's quite clear. You see, if I were a straight person and I had a foreign wife, I could get married to her, and my wife would have a PIO or an OCI card now, right? So she would be an overseas citizen of India and therefore amenable to the entire gamut of laws that exist in India. Since this country does not recognize marriage equality, I can therefore not get married to my partner, and therefore he, even though he desperately would love to, cannot become an OCI. He cannot become an overseas citizen of India. So then to hold that against me, that look, your partner is a foreign citizen, but you're not allowing him to become a citizen in any case, right? Because we are gay. And that is obviously a case of hostile discrimination. A person who is straight will not have that problem. A person who is gay does have that problem. So this is one indirect manner in which I say that my candidature is not being considered because of my sexuality, whatever the other reason may be. This is staring you in the face, right? I would not be the first person ever to have public office with a foreign spouse. The foreign minister has it. We had many instances of judges of the High Court, chief justices. Justice Vivian Bose, one of the greatest judges this country has ever produced, of the Supreme Court, had an English wife. Uh, there was no problem because they were married. And unfortunately, that is not the case for a queer person. We cannot get married, and therefore my partner cannot be an overseas citizen of India, cannot have an OCI card, and that is held against us. Now that is, you know, absolute.
Are you angry? Are you upset? It's been a few years, and thank you for that correction. The Collegium does recommend, and it writes to the government. I just want to underline that correction
Yeah.
4 times. But you
Hmm.
point out that the courts also took 3.5 years to get to that point. Now the centre's taken a little over a year, and the file hasn't moved.
Hmm.
You were part of that team. I just want to bring up that photograph again. It's a kind of iconic photograph with Medika Guruswamy, Saurabh Kirpal. Can we just pull up that picture on the lawns of the court? I just want our audience to have a look. This is the team that actually decriminalized or fought to decriminalize homosexuality, and much is owed to this team. You're one of that iconic team, and then you, as a gay person, are obstructed after this decriminalization, right? I want to ask you, does this make you angry, sad? Have you given up? Like, have you turned your back on the dreams of becoming a judge? Where are you today, finally, Saurabh?
Well, uh, look, when the battle for decriminalization was being fought in 2018, the judgment came. We had a judgment against us in 2013. So we are used to fighting battles. As a queer person, from the day you are born and you discover your sexuality, you're fighting battles, right? So I think I have a pretty thick skin. I've been fighting for the last 50 years, Barkha. I'm not one to back down. I don't get sad. I understand why people are the way they are. Uh, Part of the requirement that I say that I must have empathy also makes me understand why people are against equality. It's because they don't truly understand what it means to be a queer person. They don't have queer friends. They don't know anything. So it's my job to educate as well. And if I start getting angry, I will not be doing justice to forget myself, but to that community that I hope to fight for. So I'm not angry. I'm not sad. I certainly am not giving up. I'm in it for the long haul.
And I hope that we get to see India's first openly gay judge sooner rather than later. I also do think it's an important point that you make that while we have seen your case very much as a collegium versus center battle, delaying tactics on either side have actually really played a part in your case. And I do hope that it was on. I remember Arun Jaitley, whom you used to know very well, was one of the key forces that encouraged this government to not oppose the decriminalization of homosexuality in the court. So just remembering that moment and hoping that forward-thinking people in the government do respond differently. Thank you, Saurabh. Congratulations on the book. Take care, and we hope to see Judge or Justice Saurabh Kirpal sooner rather than later. All the best.
Thanks, Barkha. Thanks for having me.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.